Okay, good afternoon, everybody, and welcome to today's Division III webinar for the month of December. My name is Bill Regan. I'm the Associate Director for Academic Membership Affairs for Division III. I am joined by my esteemed colleague, Jeff Myers, who everyone I think knows is the Director in Academic Membership Services overseeing Division III. Today's webinar is really focused on the convention legislation. So this is one of a couple opportunities for you to have the opportunity to get a quick overview of those legislative proposals, as well as the opportunity to ask any questions. So, Allie, the first proposal you'll see is Proposal 2022-1. It is to provide the President and Council with the ability to adopt emergency legislation. As you can see, this has an immediate effective date, which means if adopted at the convention, would become immediately effective. This proposal was sponsored by the Division III President's Council, as well as Management Council and the Interpretations and Legislation Committee. Currently, between conventions, the councils have the ability to adopt legislation only if it is considered non-controversial legislation. That's legislation that's clearly necessary to promote the normal and ordinary administration of the division's legislation or business. What this proposal will do is add an additional opportunity for the President's Council only to adopt emergency legislation. It can do that if it has a 3/4 majority of the President's Council in support of it. Additionally, any proposal similar to a non-controversial proposal would have to be ratified at the next convention. So what is considered an emergency legislative event? It's one that would need a response because of a court order, an alternative dispute resolution, or some type of government order, or when the presidents deem it necessary to limit or avoid NCA liability as a result of litigation or some type of government proceeding, or when the significant values or harm are at stake and the use of the regular legislative cycle is likely to cause undue hardship to the association or the Division III membership. Next proposal is 2022-2, and this proposal would move the certification of amateurism for international student athletes from member institutions to the Eligibility Center. This proposal has an effective date of August 1, 2023. It's a bit of a delayed effective date. What it does is really provide the opportunity for the Eligibility Center to wrap up its operations, as well as provide opportunity for the Division III membership to provide education to any prospective student athletes that they're currently recruiting. This proposal itself was sponsored by the membership, as you can see, by the Allegheny Mountain Collegiate Conference, the Minnesota Intercollegiate Athletic Conference, and the Little East Conference. Currently, the pre-enrollment participation amateur status of any international prospective student athlete is being reviewed and determined by our Division III membership. And the Division III membership is currently using the International Student Athlete Form to conduct that certification. What this proposal would do would be to move the certification of those two elements, the pre-enrollment participation, as well as amateurism, to the Eligibility Center. It would relieve for all international prospective student athletes. So effectively it would relieve that obligation from our Division III membership and move that over to the Eligibility Center. The cost for that certification would also get moved to the prospective student athletes. The next proposal is 2022-3. This proposal would specify that Division III student athlete uses a season of participation competition only when that student athlete competes against outside competition. The effective date for this proposal is August 1, 2022. And you can see the source also comes from the membership, the Atlantic East Conference, the Empire 8, and the Liberty League. Currently, the rule says the student athlete uses one of their 4 seasons of participation. When the student athlete continues to participate after the first contest, after they become engaged in athletic-related activity with that particular team. So it's really based on the student athlete's participation, not just competition. What this rule would do is would change that so that a student athlete would only be charged with one of their 4 seasons if the student athlete actually engages in competition and that competition is against outside competition. It doesn't change the number of terms or the number of seasons. It simply is just saying now competition is the trigger for the use of a season. It effectively creates what's known commonly as an opportunity for a redshirt year.
So regarding the Eligibility Center, do we know the cost or the typical cost?
Yeah, so I think what we do is right now, we've been working with the Eligibility Center. What we have is a rough estimate, obviously always subject to change, but the Eligibility Center believes it would be right around the $70 mark.
Is there an opportunity to have that fee waived?
Yeah, currently for international students, there is not an opportunity for the fee to be waived.
How does this proposal impact club sport athletes per bylaw 14.02.6.2?
Yeah, so I don't think I just read really quickly the club sport participation. That would not change. That exception based on this, I would imagine the club sport exception still would apply, but that is a good question that we should follow up on just to make sure. All right, next proposal is 2022-4. This proposal deals with those institutions that have a Division I sport in addition to the Division III sports that they currently sponsor. This proposal also has an immediate effective date, which means, again, if adopted, would become effective immediately, right after convention. The sources are, it's a membership-sponsored proposal again, Empire 8, Liberty League, and the SUNYAC. So currently, Division III institutions that sponsor Division I sport for those student athletes who are on the Division I team, the institution applies all Division I legislation for those student athletes with one exception. That exception is our financial aid regulations. They must follow Division III financial aid regulations. I will note that there have been a group of 5 of the 10 current sports that are sponsored at the Division I level. 5 of those currently already able to offer athletic-related financial aid. They were grandfathered in when this bylaw changed. The proposal itself would now permit Division I student athletes who participate in a Division I sport at a Division III institution to be able to receive athletic-related aid based on Division I legislation. So it would take for those 5 sports that currently cannot offer aid, it would allow those 5 to be able to provide the opportunity to provide athletic-related financial aid to those Division I student athletes that are participating at their institution.
Bill, I'm going to call on your colleague Jeff to answer one question that came in the chat about institutions being able to pay for the Eligibility Center certification.
Yeah, thank you, Louise. Currently, under the proposal as written, an institution would not be able to pay for the certification costs. To put that in perspective a little bit, as far as the process, the prospective student athlete is submitting information to the Eligibility Center and paying for the certification prior to becoming a student athlete and prior to determining where they may go and attend as a college. They may be getting certifications in Division I and II as well. So the question first becomes, who would pay that cost? And would that cost be some type of recruiting inducement as well? If upon enrollment they're asking to pay at that point, it'd still be considered at that point an extra benefit. And then I think the follow-up question was, can proposal be submitted in the future to allow an institution to cover a cost? That certainly could happen. The effective date for the Eligibility Center proposal is August for student athletes entering college after August 1st, 2023. So certainly a proposal could be submitted to allow for that cost to be incurred by the institution. But as of now, that is still not permissible.
For proposal number 3, does this legislation change the number of competitions?
It does not.
Does this grandfather these institutions as was the case in 2004, or does this permanently change the legislation?
Yeah, this would change the legislation for those 5 sports that currently were not grandfathered previously. So this would change the legislation to say that a Division 3 school that sponsors a Division 1 sport would be able to offer athletic related aid. I think it's also important to note that currently Division 1 has a legislative prohibition against multi-divisional classification. So apart from one exception, there can't be more multi-divisional classifications unless there's a Division 1 change, a change at the Division 1 level. The only exception is if you have sponsor a sport at the division level in one gender, you can petition to have that sport sponsored also in another gender. Okay, I will now turn it over to Jeff.
Thank you, Bill. Proposal 5 is a membership sponsored proposal sponsored by 8 conferences, as you see there, and addresses automatic qualification conditions to NCAA championships. And before we get into the proposal, we'll look at the current rule. And while there's many conditions in which a conference must satisfy in order to earn and maintain an automatic qualification to an NCAA championship in a particular sport, we're really focusing on, for the purpose of this proposal, is the number of institutions that need to sponsor that sport to satisfy the automatic qualification criteria. And that currently is 7. There are other criteria. 4 of those have to be core, there has to be a waiting period, and so on. This proposal doesn't address any of that. It's just addressing the current minimum number of schools necessary to sponsor the sport, which is 7. So how does the proposal change that current rule? It reduces the number from 7 institutions sponsoring to 6. It, again, does not change the 4 core requirement, the 2-year wait period, or any other criteria involved in the automatic qualification process. This simply changes the current minimum standard from 7 member institutions sponsoring to 6. Before pausing here, I'm going to go on to the next proposal because it is a companion proposal to this one. It's also membership sponsored, and it addresses single sport conference membership. Currently, under the current rule, I should say, to establish a single sport conference, you must have at least 7 active member NCAA institutions. This proposal would reduce that number to 6. Now, some important things to consider here. 1, this is only changing single sport conference minimum membership requirements from 7 to 6. It does not change multi-sport membership requirements. The multi-sport conferences still must have 7 members in order to form a multi-sport conference. And the rationale behind that is if the AQ qualifications are changing to 6, single sport conferences only for that one sport should not have a requirement greater than the AQ requirement. So this one, reading the 2 together, the first proposal reduces the minimum automatic qualification threshold per sport to 6. The second proposal changes single sport membership requirements from 7 to 6. Important to remember, multi-sport composition will still remain at a minimum of 7 in order to establish a multi-sport conference.
Jeff, with proposal number 5, if approved, how many additional AQs will result?
Yeah, and the championships committee discussed that. And again, at this point in time, it would be guessing what institutions could sponsor or have an AQ on only 6. It would be anticipating conference membership, so that number is just not known. And this is a governance sponsor proposal addressing the football playing season, and specifically addresses 3 areas of the playing season: the preseason, the regular season, and the spring period. And it addresses both contact limitations as well as an increase in teaching opportunities. So first, with respect to the preseason, this chart sort of reflects the areas it addresses, the current rule, and then how the proposed change to the current rule. And first, the acclimatization period would be increased by 1 day. There would then be established during the preseason period a limit of 8 days in which full equipment may be worn. Currently, there are no limits on how many of the preseason days outside the acclimatization period, dictating the amount of equipment that may be worn. It limits full contact practices to only occur on days which the student athletes are wearing full equipment, and no more than two consecutive days of full contact. And then the final condition is at the time of contact. So no more than 75 minutes per student athlete of contact per practice. We'll move on to the regular season, which is a little simpler. And simply, it states that during any week of the regular season, there's no more than 2 full equipment practices per week. The only exception being the bye week, in which they may have up to 3 full equipment practices during that week. And then we'll move on to the last part of this, which is the spring period. Currently, the spring period consists of 16 days in which no contact may occur. This would do a few things, and the purpose of the changes here is, while to decrease contact in the regular and preseason, this would increase teaching opportunities for appropriate blocking and tackling. And so for the 16 days, it doesn't change. There still is only 16 days, but now student athletes would be allowed to wear helmets on all 16 days. And for 4 of those 16 days, they would also be allowed to use shoulder pads. The shoulder pads cannot be worn until there was at least 4 helmet-only practices prior to that. And during those shoulder pad and helmet days, there would be contact permitted to teach, again, tackling and blocking. There'd be no tackling to the ground. It's focused on primarily 1v1 type teaching, not 11 on 11 type contact. The other thing to keep in mind is on the remaining 12 days, so the 12 days in which only helmets are worn and shoulder pads are not, nothing is changed from the current legislation, meaning there's no more contact allowed, no activities that weren't allowed previously or aren't currently allowed would now be allowed. It is merely putting helmets on for the entirety of the spring period. It doesn't increase or change the activities other than for those 4 days of shoulder pads.
How does this, the proposal with the preseason align with the Sports Science Institute's recommendation around acclimatization?
The Committee on Competitive Safeguards and Medical Aspect of Sports has reviewed this proposal as well as the proposals in Division 2, which is putting forth a similar proposal, and legislation that was in place this year for Division 1. That committee, in conjunction with SSI, agreed that the proposal itself was consistent with the aims of reducing head impact exposures, and ultimately offered their support for this proposal.
Does the proposal add a day to the preseason?
It does not. It does not add a day to the preseason. So the number of days, is how you calculate the first date of the preseason, all remains the same.
Thanks, Jeff. Proposal 2022-8 deals with adding equestrian as an emerging sport for women. Effective date is August 1, 2022, and once again is a membership-sponsored proposal. So currently, equestrian is not listed as one of the emerging sports for women. So what this proposal would effectively do is to add the sport of women's equestrian as an emerging sport. Additionally, what this proposal also would establish the playing and practice season legislation, as well as the membership sports sponsorship requirements for the sport. Right. Well, let's move to our final proposal, which is 2022-9, dealing with the sickle cell trait status. This proposal, again, is an August 1, 2022 effective date, and you can see this proposal was sponsored through the governance structure, starting with the Committee of Competitive Safeguard and Medical Aspects of Sports, and ultimately through the Division 3 Management Council. Under the current legislation, student athletes who are beginning their initial year of eligibility or trying out for a team are required to undergo a medical examination, and that examination should include a sickle cell solubility test, unless those student athletes produce results of a prior test or they decline and decide to sign a waiver or a release. What this proposal would do, if adopted, is that for those student athletes, they would no longer have the option to sign a waiver declining confirmation of the sickle cell test trait. So they'd have to either provide documentation of test results or would have to go an actual test as part of their medical examination.
There is a question regarding the International Student Athlete Certification. If it passes, would the institution be required to use the NCAA Eligibility Center, or could the compliance officer continue to do that certification of its international students on campus and avoid the cost?
Luis, all Division III international student athletes would be required to go through the Eligibility Center.
There's also a question regarding the eligibility proposal. Does the student use a season if they're present at the competition or if they actually compete?
It's only if they compete. So it is a competition only proposal, meaning that your eligibility is only affected if you compete during that contest. If you can stand on the sidelines in equipment, uniform, and not trigger the use of a season. It is competition only.
And so, Jeff, there's another question. You answered it, but I at least want to address that. The question is, with football and men's lacrosse, where substitutions are not documented, it would still then be up to those compliance officers to work with their athletic communication directors to determine who actually got in the game and who didn't, and in essence, using that season of competition. Is that correct?
Dynamite, Louise.
Thank you. All right. Oh, I believe this question is for the sickle cell, but the question is, the rationale speaks to privacy burdens. Can you clarify what this is referencing?
Yeah, I think without looking at the rationale, let me go back. Luis, is there another question maybe while I go back and just look at the rationale real quick?
Yes, Bill. So the next question is, again, it's with sickle cell. Insurance does not cover the cost of a sickle cell solubility test for international students. Do we know the cost of the test? And I actually know the answer to that. That test is typically, I believe, $10. At least with students in the United States, that test is now given at birth. And where could a student athlete get the test? I believe any doctor's office or clinic could give that test, but I'll defer to both of you if you have other information around that.
I don't think we have anything more detailed than that, Louise.
Proposal number 4, how would it impact dual sport athletes?
Use of a season is sports specific. So the example would be if a student athlete is a soccer student athlete and they do not compete, they wouldn't be charged a season for that sport. But if they were also a track and field student athlete and they do compete against outside competition, they would be charged one of their 4 seasons of competition against track and field. So it's important to note that the seasons of participation competition are sports specific.
If the proposal to advance competition as the trigger for the use of a season is passed, will the same apply to this bylaw, or how may this be amended?
So it's in reference to club participation. And I think to look at the club legislation in total, you're looking at, under the current rule, when does club participation actually trigger the use of the season? Or is it a way that the institution can put prospective students on that club team as a means of not triggering a season? So right now they trigger a season on a club team if you also have that varsity sport. So here they're only going to trigger, again, if it's competition, and they're using it as a means to somehow get around that redshirt rule. So merely practice wouldn't trigger a season, but competition still would if under the current rule, they would have triggered a season because of the status of your club and varsity teams.
Luis, I wonder if I can go back to the privacy issues. So, and the rationale for sickle cell, I think originally there were noted some concerns. Hey, the administration of the test, the ability to handle that for member institutions, privacy institutions should, relative to a student athlete, having to disclose medical history as well as institutional management. I think when this proposal was evaluated, they thought that all those things are legitimate issues. However, the care and the welfare of student athletes far overrides those issues at this point. It feels that most institutions are already dealing with this or administering these test results and are managing many of these contingencies on their own, and that any of the privacy issues or institutional care or the administration are far outweighed by, as I said, student athlete welfare issues.
We thank you for your time. We wish you a wonderful holiday season. And we'll see you when we have our next webinar in February. Thanks so much, everyone.